Hi, my name is Eric Olson, Director of Helps. This brief video is going to address the question, can I sell a home and have a judgment removed that's a lien on the home without having to file bankruptcy? Let me give the example. Since we deal with seniors primarily that are on Social Security, let's say you're a senior, your age is 65, you've got a property that you owe maybe $30,000 on, and it's worth $150,000. You have a property in another state where you want to move to and put a trailer house on it. So the property where you live, you've got an equity in that property of 170 plus 50 would be 120,000, because you owe 30 and it's worth 150. And the homestead exemption in that state where you have your home is 150,000. Therefore, the amount of equity you have in that home, 130,000, is less than what the homestead exemption is for that state. But someone sued you and they have a judgment against you, let's say, for example, for $50,000. And the question is, how can I get that judgment lien removed? If you file a bankruptcy, sure, your property is protected because the equity is less than the homestead exemption for that state. But then you've got the property in the other state, let's say it's worth $30,000, and there's no exemption for that. And so if you file bankruptcy, a trustee could sell that property out from under you. But you don't want that to happen. You want to be able to eventually live there. So what's your options? Well, I mean, you could sell that property in that other state, get rid of the money, and then, so you can qualify to file bankruptcy, but you don't want to do that. So that's just that example, but there's a lot of things that tie in with that. The answer is, in most states, you can have a judgment lien removed to the extent that it impairs your homestead exemption when the home is sold without having to file bankruptcy. So to give another example, if you have a home that's worth, let's say, $200,000 and you owe $150,000, and you have a judgment for $10,000, okay, and the exemption for your state is $50,000. So if you got a home that's worth $200,000, $150,000 is what you owe. $50,000 is equal to what your exemption is. And there's a judgment for $10,000. The judgment does not need to be paid. The judgment can be removed upon sale of the house, and it can be removed either by the person filing a bankruptcy, or in almost every state, it can also be removed through another process because it impairs a homestead exemption. There's reasons why certain seniors wouldn't want to file a bankruptcy to be able to remove a lien. They'd want to remove it in another way upon sale of the house if it impairs their homestead exemption. So one thing I should point out, that realtors don't know this. They never tell people this. They're not taught this. And title companies never say. I've been an attorney for 40 years. I shudder to think all the judgments that have been paid by a title company, because the title report comes back and say, hey, you have to pay this judgment. When in fact the person could have the judgment removed because it takes from their homestead money that they're entitled to. So if you have any questions, you can certainly, do some research. I'm afraid there's a lot of local attorneys that probably don't understand this concept unless they're really familiar with it and work with it every day. What helps is we're a law firm that represents seniors in order to stop collector harassment under the Fair Debt Collection Practices Act. If a person is represented by attorney, collectors can no longer bother them. Seniors' income, Social Security, pension, disability, VA benefits is all protected by federal law. Does not need to be used to pay old debt. and so seniors can use that money for their needs. And probably the vast majority of seniors have no need to file bankruptcy. Of course, if they don't pay their old debt that they owe, creditors can call them, harass them, make their lives miserable. And that's what we do, is we represent seniors nationwide as their attorney to stop collectors from harassing them. The Fair Debt Collection Practices Act provides that if you have an attorney, they have to leave you alone. So hopefully this gives you some insight on this particular area. It comes up often enough that I prepared this video. And you have a great day.